Mr. Zimmerman, please stand up. I'll remind you, sir, that you're still under oath from when we had you sworn in earlier before the break. Did you now have sufficient time to discuss with your attorneys whether or not you wanted to testify in this case?
Yes, Your Honor.
And I don't need to know what was said, but after those discussions, have you made a decision?
Yes, Your Honor.
And what is your decision, sir?
After consulting with counsel, not to testify, Your Honor.
Okay, you understand that no matter what counsel says to you, it's still your decision. Do you understand that?
Yes, Your Honor.
Okay, and I need to know, is it your decision to not testify in this case?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And this is clearly the decision that you yourself have made.
Yes, Your Honor.
Thank you very much. Is the defense going to rest subject to any more evidence being entered? And
That's correct, Your Honor. Thank you.
is the state going to have rebuttal evidence? Testimony?
Yes, Your Honor.
And how many witnesses are you going to be calling for rebuttal?
Have at least 2 today, and one who is not available today should be available tomorrow, which we may not end up calling anyway.
Okay, I still haven't seen the proposed jury instructions. It's my understanding that a copy has been provided to the defense and a copy has been provided to Mr. Zimmerman. Is that correct, sir?
Yes, Your Honor.
Okay. Can I please have a copy? Are these 2 witnesses going to be lengthy?
I don't think so, Your Honor.
Can we do a charge conference after we excuse the jury for the day?
I don't see a reason we can't.
We can start. We have some special jury instructions to prepare and present, but we can at least get a feel. I think might now be the time for me to renew my judgment of acquittal.
Right, and then you'll rest in front of the jury and we'll go forward.
Yes.
Okay, you may proceed. Yes, I'm sorry, yes.
I think with the length of the presentation to you earlier, I'm going to certainly abbreviate and not readdress the arguments nor the case law that I address. I would certainly ask you to reconsider those. I think that the factual basis, however, has changed somewhat, and I'm not going to recount it because I know that you were sitting here along with us during the whole time of hearing it, but that the defense case has presented now evidence that I believe, uncontroverted evidence, that supports my client's contention that he acted in self-defense. That includes, of course, the most recent witness, Mr. Root. It includes Dr. DeMaio and his expert testimony in regard to the gunshot, and also the other information concerning the injuries that my client suffered. We also have a number of voice witnesses, if you will, those witnesses who have come back and testified before this court that they had no issue whatsoever and were quite firm in their position and belief and testimony under oath that it was my client who was screaming for help. And again, I don't want to belabor the point of the previous case law, but I think that you would need to decide at this point basically that there is that the state has excluded at this point in the trial a reasonable hypothesis of my client's innocent, and now with the strength of the defense presentation that they have failed to do so, and I would ask that the charges be dismissed in full.
Response?
Thank you, Your Honor. If anything, the state's position is that Dr. DeMaio certainly portrayed at least one alternative scenario where the defendant could absolutely have committed second-degree murder against Trayvon Martin, just by virtue of his answer to Mr. Delarianda's questions, that being that Mr. Martin was attempting to pull back or disengage when he was shot and murdered by this defendant. Moreover, to say that Mr. Root's testimony was uncontroverted is, I think, overstretching it even more than Mr. Root did. Certainly he was very eager to draw conclusions, but he also had to admit, finally, that he had absolutely no idea what exactly went on at the moment that this defendant shot and killed Trayvon Martin. So we believe that while the defense may have presented people to sort of enhance the dispute of facts and the inferences that can be arisen, in other words, to make it perhaps even more disputed, that the state has certainly submitted sufficient evidence and will, again, continue to do so in rebuttal to indicate that both the facts and the inferences that can be drawn therefrom would support a jury verdict as to both murder and the lesser-included manslaughter.
Very brief response. I would just ask that either the state or perhaps the court, if you're going to rule, come out or identify the state's factual scenario, their theory of the case, anything for which there is, that excludes a reasonable hypothesis of innocence of my client now that they finished their case and we finished our case. I would ask that that be articulated in some form or fashion, either by the state so that you can make the ruling, or by the court in your ruling that actually suggests that legally this judgment of acquittal should not be granted.
Okay, thank you. The court has sat here and listened to all the witnesses. I think I had previously said how many witnesses had testified both on behalf of the state and the defense, and have listened to the arguments both at the end of the close of the state's case and now at the close of the defense case. And the court's decision is the same, that there is substantial evidence, both direct and circumstantial to allow this charge to go to the jury. So we need to bring the jury back in. You need to rest in front of the jury, and the state be prepared to call your first rebuttal witness. Let's go. Are we ready to bring the jury in?
Is there a chance of finding out who the rebuttal witnesses are so we can see if there's discovery issues or?
Yes, and then we have to, at some point in time, deal with the Mr. Donnelly issue. So we could do that after we've talked about it. Who's the witness that you're going to call next?
First one will be Adam Pollock.
Right, and can you tell us who the second one is going to be?
David Lee.
David?
Lee.
Thank you.
Okay, they had a third, they just didn't know.
They didn't know if they were going to call that person tomorrow
I
night.
have to ascertain his certain availability, Your Honor. I just haven't.
When you find out tonight, would you please email the defense and let them know so they could be prepared for that in the morning?
Yes, Your Honor.
Thank
And I
you.
know the state understands that they are bound in true rebuttal. Mr. Pollock testified before. I want to make certain this is not just a re-examination of him, but it is truly in rebuttal to some particular fact that we presented in our case.
If it's not, you're free to object, and then I'll roll.
Yes, Your Honor.
Are we ready to bring the jury in?
The defense is, yes, Your Honor.
Okay, you need to, again, rest on the record.
I'll do that.
In front of the jury, I mean. Please bring the jury in.
And that will just take my announcement, correct?
Yes.
Thank you.
Please be seated. Mr. O'Mara?
Yes, if I might just to announce to the jury that there was a number of other exhibits put into evidence. I'm not going to go through them all just to identify them because we'll be talking to them about it at closing, but a number of photographs, I believe it's number 30 through 38, and there's potential of a 39.
Yes.
And then some other judicial notice matters concerning weather that we'll address with the court. But with all that in mind and now being entered into evidence, the defense would rest.
Thank you very much. Does the state have any rebuttal?
Yes, Your Honor. Call Adam Pollock.
Raise your hand, please. Do you solemnly swear affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
You may inquire.
Thank you, Your Honor. Mr. Pollock, just to remind the jury, you were the defendant's trainer at Cocapelli's Gym, is that right?
Yes, sir.
And are you now marketing the training that you gave to George Zimmerman on your website?
I'm sorry?
Are you now marketing the training that you gave to George Zimmerman on your website?
Absolutely not.
No?
What's actually going
Let
on
me
on that?
object, Your Honor, if I might. That is improper rebuttal testimony, seemingly impeachment.
Okay, well, we need to have argument about that. Approach the bench. Continue this matter outside the presence of the jury. I'm sorry about that, but if you'll please put your notepads face down, follow the deputy back into the jury room. Please be seated. Mr. Pollock, you're still on the witness stand. We're taking a 15-minute recess. You're not to discuss this case with anybody, including the lawyers, and if you'll please wait outside, we'll be with you when we reconvene. Thank you very much. Court is in recess for 15 minutes. Okay, Mr. Manti?
Yes,
You asked for additional potential citations to authority, Your Honor. I would tender one, McKee, M-C-K-E-E versus State. That is 712 Southern 2nd, 837. Generally standing for the proposition that evidence relevant to a witness's possible bias, prejudice, motive, or intent is nearly always necessary to inform the jury of any motives regarding, in this case it was a prosecution witness, but I think it applies equally. So again, in addition to the Britton case that I cited, the evidence would be admissible for that purpose.
But what about the rule, the evidentiary rule that you can't call a witness for the purpose of impeaching?
Well, I'm not necessarily calling him to impeach him, because impeachment would mean that I am contradicting some of his earlier testimony. I am perhaps calling him to impeach the testimony of Mr. Root, but that's not calling him to impeach this witness. If this witness denies or says something that is contradicted by the actual written record, then it may be necessary to impeach him, but I don't think he's going to deny that that's on his website. He may offer an explanation. That wouldn't be calling.
What is within the website that would contradict any evidence offered by Mr. Root?
Well, I don't know that. As far as contradicting, he said that I believe he characterized Mr. Pollack as uninterested or unbiased, or one of those, that characterization. I forget the exact word he used, but that he placed extra weight on his consultation for that reason. So it would not necessarily just contradict. I think it's also either contradict or help explain.
Okay, defense.
It has to, if it's impeachment, it's impeachment, and it has to impeach something. So let's talk about what it's being presented for. And we read from the same Bible, so I looked at Earhart for some insight on this, and what he says is that it actually has to be relevant. It has to truly impeach or address an issue of bias. In effect, if what we're looking at is this witness's, Mr. Pollack's bias and how he may have presented in a way that evidences his own personal financial interest, which I guess is the underlying request of the state, that they impeach or make believe not impeach, but impeach this witness by saying, you might be trying to make money on Mr. Zimmerman because he came to your gym. Let's just think this through for a second, and I think the court has to include within its context of authority common sense. So let's look at it through common sense filter for a moment. This witness who wants to tell somebody to come to his gym because I trained Mr. Zimmerman got in front of this witness, in front of this jury, and under oath said he went from a 0.5 a year when he first got to me to maybe a 0.1, that he was soft then and he's soft now. There's no financial interest that this witness furthered by his testimony, and that's why it's sort of bizarro impeachment, because it doesn't impeach what it would normally impeach. If this witness came in and said, this guy is great, and because of my training, he can kick anybody's butt, then maybe I would come in and say, wait a minute, aren't you making money by saying that you do a great job? We don't have that. We have the opposite of that.
Okay. What we have here and what the state had cited to the court was Britton versus State, 414 Southern 2nd, 638, and it is a 5th District Court of Appeal case. And in that case, the state didn't call this witness in their case in chief and called him in their rebuttal. And the court indicates that rebuttal evidence explains or contradicts material evidence offered by a defendant. And the testimony delivered by the state's rebuttal witness was neither explained nor contradicted any evidence offered by the defendant in that case. Permitting the testimony, however, was not error because the court has discretion in the order of presentation. What you're trying to do with Mr. Pollack is not an order of presentation. It is to impeach your own witness. You're calling him as a witness to impeach him by saying that he's advertising on a website about the Zimmerman trial and the Zimmerman training that he received at the gym. I don't think that that's allowed, and I'm going to sustain the objection.
Very well, Your Honor.
So I don't know how you want to handle this in front of the jury. We could tell them that Mr. Pollock is not going to be testifying, and you could call your next witness. Or we could have him come on here if you have any other questions that you wanted to ask him. This was the sole purpose?
Yes, Your Honor. I was going to call him and ask him about that particular website advertisement.
All right, well then the state agrees based upon the court's ruling, there's no reason to have Mr. Pollock come back into the courtroom?
Yes, Your Honor.
All right.
The next witness similarly has some objections to the presentation. We may as well take that up before the jury comes back in, if we could.
All right, and the next witness's name is, please?
Is Mr. David Lee, Your Honor?
All right, and what is the purpose for calling Mr. Lee?
Judge, could I have just a minute?
Yes, you may.
Mr. Pollock is going to be released from his...
Yes, Mr. Pollock will be released.
Judge, on balance, the state is not going to be calling Mr. Lee.
Right, and how about the other witness that the state was going to check on for tomorrow?
I haven't left the courtroom to be able to check on that, Your Honor. I haven't yet known.
Surprisingly, we have an objection to the presentation of that evidence as well, and they need to address it.
Maybe we can proffer it. What is the name of that witness?
He is Mr. Fleischman, Your Honor.
And his first name?
I believe it's Arthur.
Arthur? And what is the objection to that?
Who is he? He is the agent with the Bureau of Alcohol, Beverage, and Tobacco for whom the defendant was arrested for committing battery on a law enforcement officer. That is who he is.
Okay, and the purpose for calling him?
Because the defense has gone to great lengths to assert that the defendant is, despite all the other circumstances, largely incapable of fighting. I think this agent would offer a different perspective on that, where he would be permitted to testify. Specifically, he would essentially say that while he and some of his fellow law enforcement officers were engaged in arresting some persons at a bar at which the defendant was, that they had the individuals outside subject to being arrested, and the defendant came out. One of them, or at least one of the people being arrested, was one of the defendant's friends. The agents, this agent in particular, will say that he identified himself to the defendant, showed him his badge and identification, told him that he needed to leave while they were effecting the arrest of these individuals, and the defendant actually attacked him. That would be his testimony.
My response, Your Honor? One, it's a prior bad act that the state is trying to get in improperly, firstly. Secondly, of course, there's a 403 analysis that needs to be done by this court. Thirdly, you need to probably know a bit more about the facts of the case just so you can address it. The agents were undercover at a location out by UCF and had taken a friend of Mr. Zimmerman's out bodily because
Can I have the time frame in this, please?
It is 2005, Your Honor, so we're talking 8 years ago. Before, just so the court's aware, before he wanted to become a prosecutor, before he got his concealed weapons permit, where they did a background check, before he did the ride-along with Sanford Police Department. The reason why all of that was probably able to be accomplished by Mr. Zimmerman was that in 2005, when these agents grabbed his friend, who seemed to be underage, dragged him outside, and I think they'll probably acknowledge that that's how they accomplished it. Mr. Zimmerman, since they were in plain clothes, I think the officers will say that at some point they brought out their lanyards, but I think this court, previous court, Judge Lester, when he addressed this very same issue, I think opined succinctly that the way that these things are handled out by UCF is that the agents go in there sort of, I don't know if he used the word Gestapo, but something like that. Anyway, so they take him outside. Mrs. Zimmerman goes outside to ask exactly what transpired. The officers didn't like the idea that someone was getting them in their way of what they thought that they were doing properly. And they arrested Mrs. Zimmerman. I never heard that he attacked him. I don't think that's in the police report. Maybe Mr. Manti can proffer the police report to the court. But in any case, he was arrested for battery on a law enforcement officer. That went to the state attorney's office, who dropped it down immediately to a misdemeanor, which you know from your experience they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went into pretrial diversion. Having gone to pretrial diversion, he successfully completed that. They dropped the charges completely. So 8 years ago, he was, in fact, over-arrested for something. The initial prosecutor to review it identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're clear, however, that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very witnesses that the state attorney's office has relied on throughout this case, particularly those interviewed by the Florida Department of Law Enforcement, and most particularly the Federal Bureau of Investigation, when they did their "Are you a racist?" interview of everybody who my client talked to, including family members, a lot of people from retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses to counter this one witness that my client is peaceful, nonviolent, friendly, mellow, and everything else. Information the state, and the reason why I present it now, information the state is well aware
I told you
of.
when we're at the bench, I really don't like these, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to present within the bounds of the law and the rules of evidence, and they do so at their own peril for opening any doors that may be available. So I don't, you all are experienced lawyers, and you know what you can and cannot do, or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument. If he is in fact available and you're seeking to have him testify, we can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call?
No, Your Honor.
Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or not.
If you allow this, I'm sorry.
Right. So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there will either be some more testimony in the morning. We'll do our jury instructions tonight, finish them up in the morning, and I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
I presume that only one attorney will be handling closing for the state, correct, as per your normal course?
Well, I think in any other times that we allow another attorney to do the rebuttal. I've always done it that way, so if that's how they choose to do that.
I object.
Okay. Your objection's overruled.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state but can present to the court as well as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is the circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
When do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get it to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client and maybe a couple of other polishings, but I think that's the
How
focus.
long do you think that argument is going to take on the jury instructions? I'm just trying to get a feel for time.
Oh, I think half an hour. I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court when the facts support it. It's allowable, so I'm not going to retrain anyone on that. The Gibbs case just defines provoked because it's not otherwise defined.
Okay, and if you're not ready to present that to the state yet, I'd rather wait for the argument. I'm just trying to get a scheduling
Sure.
idea right now. If I were to have released the jury to recess for the evening and bring them back at 10 in the morning, the state can start their 2 hours, if there's not going to be any further rebuttal, could start their 2 hours portion of their closing statement. They could go to lunch. The defense can do their 3 hours and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
Is now an opportunity, maybe after the jury's
we need
released,
to do the Donnelly hearing also.
to the Donnelly and also to address the issue of their rebuttal. And the reason why I suggest that now rather than tomorrow is if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event and the other
Well, none of
things.
this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
Okay, then we'll wait and see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in.
I need to make sure.
Please be seated. Ladies and gentlemen, again, we have some more work that we need to do outside your presence, and instead of keeping you back there in the jury room, I'm going to let you recess for the evening. I just wanted to tell you the state of where we are. I hate to ever tell anybody what I anticipate will happen, because as soon as I say it, something else occurs. But we do anticipate to go to closing statements tomorrow. And since there'll be some more work that we would have to do in the morning, I'm going to have you come back at 10 a.m. So it gives you a little bit more time in the morning. When I have you recess for the evening, I want to give you the instructions. During the overnight recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves nor with anybody else. You're not to use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? With that, put your notepads down, follow Deputy Jarvis, and have a good evening.